Hello everyone. So we are starting this channel keeping in mind the needs of students who are appearing for examinations, especially public examinations or the professional examinations. As such, mainly focusing on law. The channel's aim is to read the most important concepts, maybe like a question and answer based, or the available information in a very clear manner so that the one who listens to the videos will be able to note important points as well as recollect all the answers and will be able to write the examinations in a more comfortable manner. That means the channel is meant to read for you. So here I am reading for you. That is third semester law paper. It is administrative law from first unit. The concept which is going to be covered can be given as an answer to the question something like define administrative law, discuss the relationship between constitutional law and administrative law. So let's proceed. What will be the important points that a student appearing for the examination has to mention? The first one, administrative law. The terms of administrative law themselves mean that the law relating to the administration. It determines the organization, powers, and duties of administrative authorities. These administrative authorities are also known as executives or government officials. This law relates to the organization powers and duties of administrative authorities. It is the subordinate branch of constitutional law consisting of the body of rules which govern the detailed exercise of executive functions by the officers of public authorities to whom they are entrusted by the Constitution. Basu gives the meaning as administration is a technical term referring to the sum total of acts by which the will of the state is effectuated. It is a function of the government as a whole in the broader sense, but more particularly of the executive branch of the government, that is, the residue left after the functions of the legislature and the judiciary are exhausted. Coming to definitions, several eminent jurisprudents and jurists have given the definitions of administrative law in several ways. K.C. Davis defines administrative law is the law of concerning the powers and procedures of administrative agencies, including especially the law governing judicial review of administrative action. Professor Robson defines administrative law is the governing the administration. A special note to the listeners. So, we do not claim that this will be the complete answer, but here we cover the important points that may help you in making yourself comfortable in memorizing the concepts. Right. Now, the administrative law is the law relating to public administration. It is concerned with the legal forms and constitutional status of public authorities. It deals with their powers, duties. It is also concerned with the procedures in exercising their powers. Today, the executive or administrators have become compulsory and necessary organ of India and also of every democratic state. The administrative law has become a necessary and compulsory subject of study for the law students and lawyers. It is also taught as a separate subject for BA and MA in political sciences. Relationship between the administrative law and the constitutional law. Holland writes, while constitutional law describes the various organs of the sovereign power as yet rest, administrative law describes them as in motion. Keith says it is logically impossible to distinguish administrative law from constitutional law, and all attempts to do so are artificial. The consensus of opinion amongst English jurisprudents and jurists is the distinction between constitutional law and administrative law is one of degree and convenience rather than of principle. The constitutional law deals with the relationship between the state and individual, the relationship between the different branches of the state, such as the executive, the legislative, and the judiciary. The Constitution of India, which came into effect from January 26, 1950, is the lengthiest written constitution in the world. Although its administrative provisions are to a large extent based on the Government of India Act 1935, it also contains various other provisions that were drawn from other constitutions in the world at the time of its creation. It provides details of the administration of both the Union and the states. The codifies the relations between the federal government and the state governments. Also incorporated into the text are a chapter on the fundamental rights of citizens as well as a chapter on directive principles of state policy. And distinction between the constitutional law and the administrative law. The constitutional law is genus. The Constitution of India 1950 is the mother of all laws of India. The same situation is prevailing in almost all democratic countries. Whereas the administrative law is a species of the constitutional law. The constitutional law deals with various organs of the state. The administrative law deals with those organs as in motion or function. The constitutional law deals with the structure of the state. The administrative law deals with the functions of the state. The constitution law is the supreme and highest law in the country. The administrative law is subordinate to the constitutional law. The constitutional law gives the guidelines for the regard to the general principles relating to organization and powers of organs of state and their relations between the citizens and the state. It touches almost all branches of law in the country. Whereas the administrative law deals in detail with the powers and functions of the administrative authorities. It also gives the guidelines about the international relations, that is, the constitutional law also gives the guidelines about the international relations, whereas the administrative law does not deal with the international law. It deals exclusively with the powers and functions of administrative authorities. The constitutional law deals with the general principles of the state pertaining to all branches, whereas the administrative law deals in detail with the powers and functions of the administrative authorities, including the civil services, public departments, local authorities, and other statutory bodies exercising administrative powers, quasi-judicial powers, etc. The constitutional law demarcates the constitutional status of ministers and public servants, whereas the administrative law is concerned with the organization of the services or the working of the various government departments. The constitutional law imposes certain negative duties against the administrators, that is, not to violate the fundamental rights of the citizens, etc. The Constitution also imposes certain positive duties on administrators with implementation of social welfare schemes, etc. Whereas the administrative law makes the administrators have to follow the constitutional law first and next the administrative law. The constitutional law have full control over the administrative law and administrators. The administrators should perform their functions with utmost obedience to the constitutional law. The administrative law is subordinate to the constitutional law. The constitutional law is theoretical one. It gives the power of supreme legislation to the parliament, whereas the administrative law is a practical and functional one, and always is a subordinate to the constitutional law. And these are the important points that can be mentioned for this particular question. And if any suggestions are there, you can just give in comment section. Thank you for listening.